Well, I realize we're kind of in tag team here. Thank you very much for bearing with us. But this means we're very efficient. We're getting our votes done and able to address this really important question. So I want to think some more about Medicare fraud. You know, part of preventing fraud is deterrence. The government can invest billions of dollars in identifying fraud, but if major wrongdoers only get a slap on the wrist, then it doesn't mean much in terms of deterrence, and there's not much incentive to quit doing it. So let's examine how much real deterrence there is. I pulled some examples here. Last year, the Department of Justice convicted 718 people of healthcare fraud. CMS has more thoroughly scrutinized about a third of current Medicare providers and revoked over 17,000 providers' ability to bill Medicare. I think this is what you were talking about, since the passage of the ACA. Those are very impressive raw numbers, and it's a lot better than the track record of many other enforcement agencies. So good work on that. But most of these cases involve individual actors or small and mid-sized companies. When major healthcare entities are accused of defrauding Medicare, the cases seem to end in a settlement and a corporate integrity agreement, which is an alternative to being excluded from Medicare participation, where big companies are accused of breaking the law and are asked only to set up internal fraud prevention controls. So I want to start out by asking, do CMS, the HHS Inspector General, and DOJ have policies that guide them about when to pursue prosecution and when to bar Medicare participation versus when to just settle and write up a corporate integrity agreement? Mr. Martins, could I start with you?
Absolutely, ma'am. For us, just start with an example in Florida. I mean, currently right now there was a huge corporation, WellCare, which was an HMO. We took over 200 federal agents when we had information, executed search warrants on their facility in Tampa. Subsequently, we charged the executives. They went through a long trial, and they were convicted. When we were actually on site that day, the trading on Wall Street was shut down on that stock ticker. But the more important thing there is that we have to have the proof to get there. We have to have the information. So in a lot of cases, we need to have witnesses that can specifically show the intent, and we're able to prove that in conjunction with DOJ and our other law enforcement partners. So many times when you see these settlements and things, I think what happens is we haven't gotten to the point in those matters to be able to get inside and prove the direct intent on a specific individual, not necessarily the corporation.
Well, yes, but it is a corporation we're talking about here, and the corporation that should be held responsible. And you're telling me that it was easy to do for little tiny providers, but you have these large providers that have many employees and millions of dollars that are churning through and activities. And the reason you ended up with so many settlements was because you couldn't prove your case?
Well, no, we're proving the case, right? Just in a civil perspective, that we know there's false claims, right? Or there's some sort of false claim. And when we move it into the justice arena to go through with that, we may not have been able to get to the level to prove the criminal intent.
So that's what I'm just trying to understand. So the policy is that if you think you can prove criminal intent, you actually would charge and take to trial to pursue banning them from further Medicare participation?
In the case of WellCare, just as an example there, the corporation...
What I'm trying to ask about is whether or not you have a policy in place for when it is that you make the decision that you're just going to settle and tell them to clean it up internally, or you're actually going to pursue it, you're going to pursue criminal remedies, or you're going to pursue keeping them out of the Medicare system altogether.
There's not a policy. I mean, when we investigate a case, we're looking to find the evidence. And wherever the evidence takes us, and if we can get the evidence to prove the intent and work with DOJ to get that prosecuted, we do it.
Well, that's the question I'm asking about, is what the level of prosecution is. Maybe Dr. Agarwal, could you speak to that a little bit?
Sure, and I appreciate the question. We have pursued our administrative, I should say, authorities against institutional providers on the CMS side. Obviously, we hand off cases in terms of, to law enforcement to take them to trial or other kind of law enforcement activities. But we've had revocations against institutional providers, hospitals, skilled nursing facilities.
Again, the question, Dr. Agarwal, is not whether or not you've ever taken anyone forward. The question is whether there's a policy in place that distinguishes why sometimes these things settle out and don't. And I just want to turn to a couple of examples on this. HCA, the largest for-profit hospital chain in the country, in 2000, HCA paid $840 million after pleading guilty to charges of fraud and illegal kickbacks. Then, in 2003, it paid $631 million to settle the associated civil claims. At the time, this was the largest healthcare fraud settlement in U.S. history. Despite the guilty pleas, HCA wasn't barred from Medicare. Instead, it entered into an 8-year corporate integrity agreement that required the company simply to improve its compliance efforts. So what happened? 2 years ago, HCA got in trouble again, this time over allegations that one of its subsidiaries was again engaged in an illegal kickback scheme that dated back to 2007, the time when they were operating under this corporate integrity agreement. The next time out, their HCA's punishment was $16.5 million settlement and another corporate integrity agreement for the subsidiary. All of this was in a year when HCA made $1.6 billion in profits. So the question I'm trying to ask is about whether or not we really have enough punishment associated with violating the law to act as an effective deterrent. Dr. Agarwal?
I do appreciate what you're asking, and I understand the case. We do not get involved, nor do we have authority to levy exclusions or corporate integrity agreements. Those are actions taken by law enforcement. We are happy to provide assistance and support wherever we can, but ultimately those decisions are not made at CMS. What I can tell you is that we do have significant administrative authorities which are preventive and deterrent in nature, and when the bar for those administrative authorities is met, we do take action, whether it's revocation or payment suspension or whatever the authority is.
So I understand this is not strictly within your authority. Perhaps I could ask the question just slightly differently, and that is, do you think that these settlements and the corporate integrity agreements are working as an effective deterrent?
I appreciate the question. Unfortunately, I do not have the appropriate expertise to be able to address that. I do think that that needs to be a question that is addressed by law enforcement or the folks that actually administer those remedies.
Senator, I can answer the question.
Please.
Because
Mr. Chairman.
The fine was actually $1.7 billion.
Yes.
Guilty in the corporation, but nobody in the corporation went to jail. And so where is the example of this is a no-no and people shouldn't be doing this?
You know, I'm just very concerned, Mr. Chairman, that Medicare fraud has become a game of catch me if you can. And if you do catch me, it just the price of doing business. You pay a few million, shoot, maybe even $1 billion. But pay a fine and move on and alter your business practices only to the extent of figuring out where to minimize the odds of being caught. And if that's the case, we're always going to be behind on Medicare fraud. We're never going to do much to shut it down. And like I said, I started out with the good numbers, but they mostly were small-time operators. So you go after the small-time operators, but you let the big guys continue to keep everybody in business and continue in the same operations. It just seems to me that's not going to be a very effective deterrent.